different ways to establish service connection. We're talking about 5 of the primary legal ways to establish that an injury or illness was related to a person's military service. The essence of service connection is governed in statute. It's 38 USC 1110.
Mm-hmm.
This is the statute that basically provides a pathway for connecting an injury, illness, or medical condition to service. But beyond that, there are several VA regulations that govern the more precise ways to get service connection. And there's lots of different angles or theories that a veteran could pursue if they have an injury or illness that is somehow linked to their time in the military. So, Ethan, will you start us off with the first pathway, which I think is the cleanest one, and it's direct service connection?
Yeah, so direct service connection, probably the most common type of service connection theory that we see. VA is going to be looking for 3 things with direct service connection. They want to see first a current disability, second, some sort of injury or event that happened to you in service, and then third, a nexus that links those 2 things together. So there's a few specifics about what you need to submit to prove. You can use service records, medical records, a VA examination, also lay evidence. Lay evidence is important, and the law says that VA still has to consider it. However, for a diagnosis, you're generally going to require medical evidence from a treatment provider, from one of VA's medical examiners, someone who has medical expertise to actually diagnose a condition. And then same with a nexus. Connecting your current disability to service is also going to require some form of medical expertise. However, you can still use lay statements to describe what happened to you in service, your injury, your history of symptoms since that injury, and it can still be a really valuable resource to support your claim.
Great.
So the key takeaway, though, is that direct service connection is about linking your condition directly to service. You don't need a flawless claim. You just need to prove those 3 elements.
Exactly. And you mentioned lay evidence, and there's plenty of court cases that we talk about in videos and put on our blog. Buchanan comes to mind,
Mm-hmm.
Fountain. This line of cases confirms that lay evidence is important and needs to be considered to the
Mm-hmm.
extent that the person can speak to the circumstance that they're describing.
Mm-hmm.
As Ethan mentioned, there are times when medical evidence is needed, but for anyone working on a direct service connection issue, lay evidence surrounding the circumstances that you're trying to prove to VA can be really helpful and powerful. The second pathway to talk about is secondary service connection. This is governed by 38 CFR 3.310, and the CFR is the Code of Federal Regulations that govern VA regulations that we apply all the time in our claims and appeals. And secondary service connection applies when a service-connected disability causes or aggravates another condition. So, for example, if a veteran sustains a leg injury in service, they might seek direct service connection and ask for benefits for that leg injury because it occurred in service. But then if that leg injury leads to other issues later, like secondary joint pain, maybe some back pain as a result of like an altered gait or something like that, stemming from the leg injury, then anything that does stem from the leg injury can also be compensable. And that's the secondary service connection theory. There's lots of different ways that different types of in-service injuries could lead later in life to progressive worsening or even causing some other injuries.
Some common ones we see are complications of diabetes or even treatment for a disability. If you go through chemotherapy or treatment for a cancer and have additional disability because of that, that is also eligible for secondary service connection if the primary condition was related to service. Exactly.
That's a great point, too, about medication. We've seen cases where sometimes even psychiatric medications or other types of medications for a directly service-connected injury could lead to side effects like hypertension. And so those things are important to keep in mind. VA will not always service connect those things, and you might not even have those issues at the time that you're seeking direct service connection. So over time, if a service-connected illness causes or aggravates another one, then keep in mind the secondary service connection theory.
Yeah, so the third pathway is presumptive service connection. This is where VA law steps in to fill in some of the facts that might be difficult for veterans to prove. Some of the important statutes here are 38 USC 1112 and 1116. There are a few other regulations like 38 CFR 3.307 and 3.309. This says that VA presumes service connection for certain conditions or presumes exposure based on service in certain locations. So this includes chronic diseases if your certain disabilities manifested within a year of service, Gulf War exposure, conditions related to herbicide exposure, all sorts of toxic exposure. VA has identified certain conditions that they will just automatically associate with that exposure. So one example is the presumption of herbicide exposure for veterans. So if a veteran served in Vietnam or Thailand between 1962 and 1975, the veteran doesn't have to prove actual exposure. They just have to show service in the location. Then the law steps in to just assume that veteran was exposed. Similarly, certain conditions are associated with certain types of exposure. So Camp Lejeune exposure has bladder cancer, breast cancer, other disabilities. Again, the veteran doesn't have to prove the nexus. They just have to prove they served at the location, they have the disability, and the law steps in to fill everything else. Importantly, presumption doesn't mean automatic service connection. You're still going to need to show you have this disability through medical records. You're going to need to show that you served in a certain location to qualify for the presumption. But it does remove a lot of the burden of some of the really hard stuff to prove for veterans. It's very hard to produce evidence that you were actually exposed to Agent Orange. So that's why these presumptions exist in the law, to make it a lot easier for veterans to establish those parts of their claim.
Exactly. And it's good to know about which presumption applies to you, what specific burden is relieved from the person claiming the benefit. As Ethan mentioned, there are some presumptions that exposure occurred if you had service in a time and place. There's also some presumption that an in-service event caused another thing. Mm-hmm. So sometimes we're taking away the in-service event requirement that you talked about a few minutes ago. Sometimes it's nexus. So there's still work to be done, but usually the presumption will help alleviate the burden, at least as to one of the service connection prongs. Mm-hmm. Another pathway to service connection, this one's a little complicated, service connection by aggravation. So as a general rule, the presumption of soundness exists to say that if a person entered service without any conditions noted on their entrance exam, they're presumed sound at entry. So unless there's evidence that a condition pre-existed service and was not aggravated by service, then a veteran is presumed to not have that condition at the time that they enlisted. So later, maybe if they develop something, they could get benefits for that condition. But if a veteran does have a condition that pre-exists service that was aggravated during service, they may be able to seek service connection under 38 U.S.C. 1111 and 1153, and also through the regulation at 38 CFR 3.306. These are pretty complicated issues. Mm-hmm. The presumption of soundness is a very legalese sort of set of requirements or parameters that's established, and the law wants to protect veterans from later being told by the VA, like, oh, no, actually, this injury that you claim stems from service actually pre-existed service. And that's all good. Mm-hmm. But if a veteran does have an issue that pre-existed service, there is still a pathway to get service-connected benefits for it if they can prove that it was aggravated beyond the natural progression of the condition during their time in the military. Mm-hmm. So episodic, temporary flare-ups, that's not going to be enough to establish service connection by aggravation, but showing that the condition was permanently altered or, substantially worsened, for the long run during service is one way to get benefits for a condition that did pre-exist service.
So speaking of complicated, last up, we have 1151 claims. So this is under 38 U.S.C. 1151, and there's a regulation 38 CFR 3.361. 1151 claims involve veterans suffering additional disability as a result of VA medical treatment, surgery, or care. So you can get compensation if you develop a disability due to medical negligence, lack of proper skill, error in judgment from a medical professional, or an event that occurs during treatment that is not reasonably foreseeable. Reasonably foreseeable means it's not an expected complication or issue with that treatment. So known risks associated with a surgery, for example, are probably not going to qualify for 1151 benefits, even if they did result from VA treatment. However, any unforeseen consequences of a surgery or treatment at VA, you're eligible for disability compensation. They're paid as if the condition is service-connected, but it's not quite the same as traditional service connection. You're not establishing a direct relationship to service. It's more about the harm resulted from treatment at a VA facility. and it was some sort of medical negligence or unforeseen complication. Medical evidence in these cases is essential. There is a lot to show that it was, negligence or an error in judgment of the medical professional and not a routine complication of the surgery. So getting evidence on the foreseeability, the fault, what happened during the procedure is really important. It's also important if you signed any consent forms prior to the treatment, take a look to see what they informed you of, because that might make it much harder to prove you're entitled to compensation for those.
Great. Thanks, Ethan. So in a nutshell, 5 different pathways to service connection: direct, secondary, presumptive, aggravation of a pre-existing issue, and based on claims governed by 1151, as Ethan just mentioned. Some of these are simpler than others, as we've talked about, but all of them involve some burden on the claimant to produce evidence to show the link between their service and a condition that they now have. So we recommend that if anyone's working through some of these more complicated claims, definitely seek the advice of an accredited representative that can help you navigate the different legal requirements that come along with demonstrating and proving any of these service connection theories. And one final note, you can pursue multiple theories at the same time. If you have a condition that may be related to service and you're not exactly sure what theory to invoke, it's VA's duty to explore all avenues that could lead to a grant of benefits. So don't be afraid to raise multiple theories if you're not exactly sure. A layperson without medical knowledge isn't expected to have all the answers on this type of thing anyway. So great. Thanks.
Thank you.